Okay, we're back in. So agenda item number 14, the enforcement process presentation. We have Erica Calderon, our Executive Director, Kathleen Nichols, our Chief of the Division of Investigation, and Carolyn Westfall, the Deputy Attorney General.
Thank you, Dr. Bahari. I'm going to go ahead and start us off. First of all, thank you, ladies, for joining me and agreeing to do this presentation on such a short notice here. I know that this is a request that the board has had for several years, and so I wanted to deliver it at this, my first meeting with you. We'll go ahead and start with reiterating our mission, and our mission of the board is to protect the public by requiring competency, accountability, and integrity in the safe practice of medicine by osteopathic physicians and surgeons. I am presenting this along with, like Dr. Bahari said, the Chief of the Division of Investigation, Ms. Kathleen Nichols, and Carolyn Westfall with the Attorney General's Office. Business and Professions Code 2450.1 gives the board the authority to protect the public. Protection of the public shall be the highest priority for the Osteopathic Medical Board of California in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be its paramount. So what does enforcement do at Osteo, OMBC? We respond to consumer complaints, we conduct desk investigations, we impose a disciplinary action, and then we monitor the disciplinary action that is imposed, and that is through our probation program. I do have a couple of staff members present here today. We have 4 analysts, 4 associate governmental program analysts in the enforcement unit. Beth Dutchler, she is right in the front center. You heard from Corey Sparks, our lead analyst, who is going to be leaving us soon, but he is also part of enforcement. We have Robin Mattson and Steve Lai, who is also present here today. I mentioned earlier that one of the very first projects that I came to help with was the revamping of our consumer complaint form. Wanted to point that out for our consumers to give them an idea where they can find this consumer complaint form. So it's on our website, www.ombc.ca.gov, under the Consumer tab and under Complaints. We did mention earlier that we included additional instructions to this consumer complaint form, allowing the public a little bit more access to knowing what it is that we need to conduct our desk investigations. We added more spacing to allow for more details of the complaint, and then also instructions for them to include additional pertinent information that they may have in their possession at the time of submission that will be very extremely relevant for our desk investigations. We also added our releases. We did not have those releases attached. They were separate complaint documents in the past, and by doing this, we decided that it would save us some processing time of going back and forth. In addition, it allowed us to conduct more investigations than usual. Sometimes it's very hard to continue on with a desk investigation because we cannot obtain a medical release. Consumers will file a complaint, and shortly after will go silent for a while, and we are unable to locate them. So we figured by adding the release up front, letting them know that this is a very key, important function that we need in order to proceed, that we would save some time and also allow for more consumer complaints to go through. So I wanted to go ahead and talk about the phases of the enforcement process. We have the receipt of the complaint, the desk investigation, which is the phase where we collect the medical records and all the evidence as stated in the allegations. Earlier, as I mentioned, we're talking about medical records any text messages, any videos, recording, all of that is very pertinent. Police reports, court documents, and some of those sexual misconduct cases would be relevant. We also have the investigative stage, which is led by the Division of Investigations. And then we have the ability to go ahead and do cites and fines for minor lower-level violations, such as medical record keeping and or a failure to update an address, or actually respond to the board for submission of evidence and records. We do have a pre-accusation PLR that we are able to utilize, and then we also have the process of referring our cases to the Attorney General's office for actual filing of an accusation. And then we also have the ability to file with the DA's office for criminal prosecution in some of those cases. Examples of some of those cases could be our prescribing cases and or our sexual misconduct. So our complaints are received. It starts off obviously with patient care. Consumer finds that there's a matter that they are concerned with. They file their complaint. This can come directly from the patient, can come from a patient's family member, patient advocate, another licensee, also through mandated reporting such as an 801 report, which is the settlement and judgment or arbitration award, and also an 805 report, which is a peer review or health facility report. Other government agencies can also file these, such as Department of Public Health, the DA's office, law enforcement, CHP. We've had numerous departments filing as well. Anonymous and miscellaneous complaints do come through a lot. They are investigative. We just, for anonymous, sometimes we have a hard time moving it along, especially if there's very little information that's given to us, especially when it's pertinent information, such as a patient name, a date of when the incident occurred, or where the situation, happened. So we do not discourage them. We obviously move forward as much as we can, but they do tend to be a little limited in our abilities to proceed with. We do have a process called the initial initiation process of our complaints. We talked a little bit about our mandate. We have to initiate our cases within 10 days. We need to acknowledge them. They need to get entered into our BRIE system to be, issued a case number, a control number, so that we can track our complaint. And in this process, we also have staff that are reviewing to make sure that we have that information and that we have, most importantly, jurisdiction to actually proceed. There are some non-jurisdictional issues that I have here listed for you, such as demeanor issues, wait times, or cost for services rendered. With that, I do like to say that we do proceed reviewing cases where there is double billing. The cost of services rendered is more so when there's a dispute between the client, the patient, and or the facility for an actual service that did occur, where they were quoted one amount and then they were charged a different. There is also a process during the triage portion, and that is also to look for high priority cases. So we like to move those along very quickly. Some of the things that we look for are are sexual misconduct, patient impairment that deals with drugs and alcohol or mental conditions. In addition, if our licensee has already been placed on probation, we do like to move those cases along. There's obviously some underlying situation where they have already been placed on probation, and we just, for consumer protection, we need to prioritize those. So what does the complaint, what are some other keys that we look at that come into play? And that would be physician's history. Like I mentioned, are there any pending investigations already at the field with DFI? Those we like to move along, especially if there are similar allegations. If DFI is already leading a prescribing case and we have another one coming through, we do like to expedite that, just so that DFI has the most information possible to move the case along. If there are any disciplinary proceedings already in place, let's say that there's an accusation already pending, if we have a new matter that actually has evidence to pursue, that we can pursue, we would like to go ahead and expedite that as well. The Attorney General needs to have as much information as possible because we do amended accusations. I mentioned earlier, what should we obtain? We should obtain medical records, police reports, court documents, a physician response. The physician has we actually have the authority, we are required to go ahead and request a response from the physician. There are some cases that we don't do that up front, and that is our high priority cases, so I do want to clarify that. But in some situations where it is a quality of care scenario, we do contact the physician. We also collect the records and obtain a written response. We do send our cases to a consultant review, and I mentioned earlier the need for us to promote bringing on more consultants, especially for those quality of care cases. Before they go to further investigation, they do require to be reviewed by a consultant. So the process, again, is we obtain the release, and then we contact the physician for a treatment summary, and we collect certified records. So what are some possible outcomes after that initial medical consultant review? We can issue a citation and fine for minor violations, and I mentioned earlier, failure to provide medical records, record-keeping issues, false advertisement, or we can refer the case for further investigation to DFI, or in some situations where it's founded that the allegations have no merit, we do end up closing the matter. I'd like to go ahead and turn it over now to Ms. Kathleen Nichols, and she'll go ahead and cover the investigation process.
Okay, so to walk you through the investigation process, the first thing that's done is that the investigator reaches out to the complainant, who sometimes is the patient, sometimes not the patient, but that's where we start. We like to do that within 30 days of receiving the case referral. After the witnesses are interviewed, we need to obtain, in most cases, medical records. Sometimes those are from multiple facilities, from the subject physician, and maybe some post-op care or other treating facilities. We obtain those records by either a release or a subpoena. And then the third way we can obtain records is if it's a criminal case, we can write a search warrant to obtain the records. So you have to have one of the three, either a release from the patient, a subpoena, or a search warrant. And if the patient doesn't sign a release and we have to move towards writing a subpoena, you have to have good cause for that subpoena. So our process is we would then send the case to our in-house district medical consultant who would review the case up to date and then provide an opinion on whether there's good cause to proceed. And then if there is, then we subpoena the records. And a lot of times if the facilities don't give us the records after we subpoena, then we would refer that matter to the Attorney General's office for enforcement of that subpoena. They would work with our medical consultant, drafting declarations, going to court. So that's kind of that process for that. And then once all the records are received and we have everything, the case is reviewed by our district medical consultant. That's in preparation for the subject interview. They help kind of translate the medical issues for the investigator so that it's very clear before we interview the subject, what are the concerns, where are the parts in the records that we need to focus on. And then the next step is to actually interview the subject physician. We like to have voluntary interviews. We send out a request and we ask to schedule an interview at a mutually agreed date. A lot of times, sometimes we don't get a lot of cooperation and things get delayed. So at a certain point, we have the ability to issue a subpoena, a personal appearance subpoena to that physician, requiring their attendance at the interview. And then once we interview the physician, it would then be submitted for expert review in an expert of the same specialty of that physician. And going back to the interview of the physician, a lot of times in the interview, more information comes forward. Either the physician, they say there was another witness present, or they say there's other documents. So a lot of times there's other follow-up investigation that's needed after we've interviewed the doctor. And sometimes that involves going back to the patient or the complainant, because sometimes things are asserted, but we don't know whether that's true or not, so we have to go back to the patient and verify or obtain new information, with the goal of just completing that complete picture, so that when we send the case to the expert, they can review it fairly and they have all the information that they need. And then once we get the expert report back, then it's just a matter of reading that expert opinion. Did the expert find any departures from the standard of care? Were they simple departures or extreme departures? Do we have clear and convincing evidence to move forward? Because for our cases, it's clear and convincing to file an administrative case. For criminal cases, we would need a little higher burden of beyond reasonable doubt. So if we do think that there's enough, that would be our recommendation to the board. When we submit the case back, we will provide a recommendation. It's ultimately up to the board to decide, and also in consultation with the Attorney General's office of what their opinion is of the evidence that we've gathered. And then the types of violations and allegations, anything from gross negligence, incompetence, repeated negligent acts. That's when you have multiple simple departures that are separate and non-related. Also sexual misconduct, overprescribing, violating drug statutes, furnishing drugs without an exam. We have a lot of the aiding and abetting lately. That includes the corporate practice of medicine, where physicians might, get hired and get paid a few $1,000s a month to slap their name on as the medical director, but maybe they're not there, and there's all sorts of things going on. So a lot of those cases involve undercover operations, where we actually send investigators in posing as patients, trying to figure out what services they're providing, what type of licensed professionals are there. So that's kind of how those are investigated. Also, other types of violations, physician misconduct. They could be convicted of a crime, substance abuse, fraud, and then the series of 820 issues, physician mental and physical illness. If there's any question about a doctor's competency, we would obviously want to intervene on those cases early. And then minor, sometimes record-keeping violations is what an expert finds. And possible outcomes that the board is the one deciding what to do. They can issue a cite and fine. We can refer it for criminal action for the district attorney. They can issue a pre-accusation public letter of reprimand, or they could refer the matter to the AG's office to review for possible disciplinary actions. And then there's some interim actions that can also be done. PC-23, that's when there's charges filed in state court, where we can actually go in at that hearing and ask the judge to suspend the physician's license as a condition of their bail. There is notice that is required, that the subject has to be given notice, so that comes into play as well. Interim suspension orders, that's when the cases are so serious that we feel the public's at risk, it's a danger to the public, and if we have an expert opinion to support that, the board could pursue an interim suspension order. Also includes petition to compel. For example, if we had an impairment case and we had information that a doctor was impaired, but they refused to give us a urine test or participate in any evaluation, if there's enough evidence, the board could move forward with a petition to compel that exam. And then, of course, if there's no evidence that is substantiated at the end of the case, the other option is just to close the case. And then, like I mentioned in my update, this year we started a new non-sworn unit. The purpose of that was just to help some of the smaller boards that didn't really have the bandwidth to have their own non-sworn investigators as part of the board. So we converted 3 sworn positions into non-sworn so that they can help assist working some of the less serious, less complex cases that don't necessarily need a sworn investigator. Now, prescribing cases do go to sworn because a lot of times we need to get the original prescriptions and you have to be a peace officer to do that. But sometimes the quality of care cases where it's one patient, one medical issue, the non-sworn special investigators are very highly trained as well. They're very capable of doing quality, thorough investigations, plus the added bonus of it being a potential cost savings for the board. because the hourly rate is less than the sworn investigators. So we're looking forward to just having that unit develop and seeing how it works for the board. Right now, it looks like the 3 positions we have allocated is enough to deal with the workload. So as we move forward, we'll be assessing that as well, just to make sure that their caseloads stay reasonable.
All right, I'm Carolyn Westfall. I'm a Deputy Attorney General out of the San Diego office. I carry a caseload for all the licensing boards we support, but I also serve as the liaison to this board. So I field questions from the Executive Director and her staff on legal issues pertaining to enforcement actions. After the investigation is complete, the case is submitted to our office for legal review. We could review it and send it back, suggesting that additional investigation is required before we think we can meet our burden of proof. We might recommend some lower sanction, like a cite and fine or a public letter of reprimand for more de minimis allegations. But usually what we do is we accept the case, and we would file an accusation when we believe we have clear and convincing evidence to prove the physician engaged in unprofessional conduct. The accusation must be filed before the expiration of the statute of limitations, which for the most part is 3 years from the date the board learned of the event or 7 years from the event, whichever is sooner. Unless there's some other interim order issued, like that PC-23 or an ISO issued, the accusation would be the first public document that's posted on the board's website. The accusation is served upon the licensee, but it's posted on the website also to put the public on notice of the charges that have been levied against the physician. The accusation is the legal document that's laying out not just the charges, but the jurisdictions, so all the relevant statutes that are at play in the case, the charges, and then a factual sort of synopsis supporting the charges, and then at the end of the document is sort of the prayer, what we're hoping to achieve at the end of the case. A medical license is actually considered a person's property, and the government, the board, can't take the property without providing due process of law. So the accusation and the process that follows is essentially providing that due process to the licensee, giving them an opportunity to be heard before their license can be taken. After we file the accusation, the next step is to wait for the licensee to file a notice of defense. That's where they're contesting the charges. If they don't file the notice of defense, after a certain period of time, the board can proceed by default. And essentially what would happen is you would just revoke the license. If the notice of defense is received, then the ball starts to roll of preparing this case to go to hearing. So we exchange discovery. We would attempt, of course, to resolve the case short of a hearing. So the process of settlement negotiations would occur between the Attorney General and either the licensee directly or their attorney if they've hired one. Any settlement offer that we extend has to be approved by, of course, the Executive Director, and we would be relying upon the disciplinary guidelines as sort of a strike zone for any settlement offer that is extended. If we're unable to reach a settlement, we proceed to a hearing in front of an ALJ at the Office of Administrative Hearings. Our hearings look very much like any other court trial. There's no jury, of course, but usually there's attorneys on each side, and we comply with the rules of the Administrative Procedure Act. We call witnesses, we admit evidence, and at the conclusion of the hearing, the ALJ would issue a proposed decision that then is submitted to the board to vote on. The ultimate outcome in any case, of course, is up to the board. So all stipulated settlements and proposed decisions are presented to the board for your consideration. After reviewing all of the documents submitted to you, you then make the ultimate decision in a case. You can adopt our stipulated settlements as presented to you, or the proposed decision as submitted by the ALJs. Your adoption of these is usually the most common result, but the board certainly can reject a stipulation and send it back to the DAG and ask them to make a different settlement offer, or to just say the case needs to go to hearing. You can reject the ALJ's proposed decision as well, and you can make minor adjustments to the decision. You can send it back and ask for more evidence to be taken, or you can just simply non-adopt and hear the case or consider the case on the total record. So that's where you would receive the transcripts and you would ask for argument from both sides, written and or oral, and make the ultimate decision after you've considered all of that information. However we reach the outcome when a decision and order has been issued by the board, the licensee then has a couple of options available to them. They can accept the decision and move on, or they can petition the board for reconsideration. You had a long discussion about that earlier in your meeting. Usually a petition for reconsideration is filed by the licensee with a request to stay the decision, and the board usually would stay the decision for a period so that they can consider that petition. The board can then grant the decision, or grant the petition and file a new decision, or they can reject the petition and the original decision would stay in effect. Once that happens, the licensee can accept the board's decision and move on, or they can appeal the decision at the Superior Court, and that process is called a writ of mandate. The Superior Court then can grant the writ or deny the writ. If they deny the writ, the licensee can accept the decision and move on, or they can appeal that decision again in the Court of Appeals, which would involve a very similar process to what happened in the Superior Court. It's just at a higher court level. So eventually the board reaches a decision and order that's final. The decision will contain the outcome of the case. It could be a dismissal of the accusation. It could be the revocation or surrender of a license. But more often than not, it contains an order of probation with terms and conditions. The highest priority of the board, of course, is public protection. However, in your disciplinary function, when not inconsistent with public protection, you're also supposed to be attempting to rehabilitate the licensee. And so the terms and conditions of probation are specifically designed to accomplish both of those goals, to protect the public and to rehabilitate the licensee. The common terms of probation where we are seeking to rehabilitate the offender would be educational programs. There might be prohibited practices. You would see that in less egregious sex cases. Oftentimes we would prohibit a physician from seeing female patients, for example. You might see prescribing restrictions where they can only prescribe certain level drugs on the schedules. You might request a practice or a billing monitor. But importantly, every case should include cost recovery. The licensee is essentially on the hook for the cost of investigation and prosecution of their case. In the more egregious cases that don't rise to the level of revocation, we would be seeking a temporary suspension of their license for a specific period. And in less egregious cases, we would be seeking a public reprimand. All disciplinary outcomes that result in a public reprimand up to revocation, of course, are posted on the board's website. And in the very rare case where we've determined we can't meet our clear and convincing burden of proof, or for some reason it's determined that no discipline is warranted against a physician, an accusation can be withdrawn or dismissed.
Just to finalize the presentation here, we do report to the Federation of State Medical Boards, the National Practitioners Data Bank. We are hoping to establish a newsletter in the near future which outlines any and all disciplinary actions that we are going to be taking. So that is another project on the horizon for me. And we are also hoping to revamp our website here very quickly and provide more, essentially more transparency to our consumers. I'd like to point out, though, that we are mandated to upload these documents, like I mentioned earlier, and you can find those by doing a license search of your physician under the Administrative Disciplinary Actions. If you can see, there's a number located right next to it that says that there is a document attached to that, and then it would take you straight to either that accusation or that disciplinary packet. That concludes our presentation. Again, I'd like to thank both Kathleen Nichols for joining me today and Carolyn Westfall. Such a short notice to put this together, and I greatly appreciate them.
You know, we appreciate this. This is something we've been asking for quite a while, in particular the website and what a complainant goes through to get their complaint uploaded and in, and then what the process was. That questions come up at a few of our board meetings in the past, so this was a very nice presentation. Any of the other board members have comment?
I just had a quick question. Thank you for that presentation. if at any point the original complainant decides to withdraw their complaint and your office is advancing the investigation, does that mean that that case would be closed, or is it on a case-by-case basis?
From the investigative side, even if a patient later on decides they want to withdraw their complaint, we will continue to move forward because a lot of times the departures are in the medical records and you wouldn't need the patient testimony. But say it was a behavioral issue or sexual misconduct, you are going to need that patient's cooperation in order to be successful. So we don't stop the investigation, we don't close the complaint, but at the end of it, then we make an assessment as to whether or not we have enough evidence to proceed without the patient's cooperation.
Understood. Thank you for that.
And from our position, my answer would be quite similar. Usually we don't need the patient's cooperation in a case. The evidence is usually contained within the medical records themselves. Even if it was a sexual misconduct case, if there are witnesses, if the doctor admits to any wrongdoing, we would certainly proceed. At the end of the day, it's a matter of can we prove unprofessional conduct by clear and convincing evidence, and we look at the totality of the evidence available to us to see if we can prove it.
Thank you.
I'll step in and add to that. At the board level, this is actually obviously once the case has been vetted that there's enough evidence to pursue an investigation. That's where Kathleen and Carolyn come in. But there are times that we do receive complaints where the patient may file it right there when they're visiting the doctor, and then the matter resolves the next day. And in those situations, as long as there's no allegations that we would be concerned about that would rise for us to, move the case along, we may consider closing it. An example would just be, the doctor was rude, possibly took 2 hours to see me, and then later on, there was a discussion between the patient and the doctor was running late because he was attending another patient. And sometimes those discussions do occur. And as long as we don't see anything else, any other, matters that are of concern, we may close it.
Thank you.
Any other comments from board members?
Yeah, just want to thank
Johnson,
you
I
for
just
all
want
your
to
hard work.
echo. Oh, sorry. I just want to echo what Dr. Buhari said, because we have been asking for this for a while, and it really, the transparency, the clarity for us so that we know the process better, as well as all of the work with the website, with trying to streamline some of the forms, such as the release and everything that you had been discussing earlier. That really helps, I think, the public to be able to proceed with any complaints that are there and know where they are in the process and what's going on. And thank you, Ms. Calderon, Ms. Westphal, and Ms. Nichols for your presentation. That was wonderful.
All right. Is there any comment from members of the public who are physically present here? Moderator, any online public comment?
This is the moderator, and at the direction of the board, I have opened up the Q&A panel for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it does look like we have a couple requests for comments, so I'll go in the order that they were received. First is from Selena Alvarez. And Selena, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Yes, hi. My name is Selena Alvarez. Do you hear me?
Yes, we can hear you.
Okay. Yes, hi. My name is Selena Alvarez. I am from Bakersfield, and I am a volunteer with Consumers Watchdog. I have suffered immediately. My doctor ignored my most extreme complications through my pregnancy, causing me to deliver my severe premature baby girl. My baby was airlifted to another hospital where I waited for months, not knowing if she would survive. But my baby girl did survive. They saved her. My beautiful baby girl was struggled with her injuries from her lifelong harm, and it has been heartbreaking to watch her struggle. My daughter cannot walk. She is on a feeding tube and she will need 24-hour care for the rest of her life. This could have been prevented. My daughter should not have to endorse this. I was so busy caring for her during the time that she was born that I did not know about the filing a complaint until I learned from it. And then I filed a complaint for my daughter. My daughter is now 8 years old. She is my miracle child. First, your board tried to tell us that it was not my OB's fault, but it was the pediatrician's fault. My advocator helped me fight that. Then, although we were told that my complaint will remain open, we received a letter closing my complaint citing that my daughters did not meet the exceptions to the statute of limitations for minor children. Children do not have the statute of limitations. They have an exception which allows them to have their complaint received and investigate until they reach the
15
age of 18.
seconds.
This board told me that my daughter did not qualify because you claimed that she was a fetus and not a minor. I will ask for you to please reopen my daughter's case and do not let the board deny her rights as a minor or any baby's rights. Thank you.
All right, this is a moderator. We'll move on to our next individual. Individuals logged in as Tracy. Tracy, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
I came here for accountability for my child and my grandchild. It is my responsibility to submit my complaint and follow it, and it is your responsibility to investigate deaths, and you are not. This board is violating the Business and Professional Code, Chapter 4, Article 5, Section 328, which requires that you investigate all deaths complaints. Yet you have continued to deny my grandson the right to an investigation. I have pushed my complaint through your enforcement process for 1 year and 8 months. I have no control number stating that my complaint was received. This is telling me that you are not investigating his case. I am doing my part. You need to do your part and communicate with me. You need to interview me if my case is dismissed. You need to tell me that my complaint is just sitting or not moving for 1 year and 8 months and why. The bottom line is that my investigator with the medical board case lied to me, telling me that it didn't matter that the two cases, the medical board and the osteopathic board, were combined for the two doctors. Therefore, I was never interviewed by an investigator for my complaint against the osteopathic doctor. Yet this board came to a conclusion with no investigating from me. This should be a matter that overturns the decisions. You are denying babies the rights for investigation. Besides my grandson, you also have denied the 7-year-old daughter the right to be an investigation and the right to the exception to the statute of limitations for minors. Don't be a board that denies babies' rights. Lastly and leastly, Deputy Attorney General is weighing on these cases prematurely, requesting their
15
closure
seconds.
without entering the process. This is an issue that we request that the Deputy Attorney General's role in the enforcement process be placed on the next board agenda. Thank you.
Right, this is the moderator. We'll move on to our next individual. Individual logged in as Monique. Monique, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
From Bakersfield and a volunteer with Consumer Watchdog. Thank you for giving us the opportunity to discuss the enforcement process with you. The stats you provide tell the story of how difficult it is to get accountability for tragic deaths from this board. I know this firsthand because this board has given us nothing but heartache in trying to file and follow a complaint for my grandson's tragic death. My grandson only lived, for 18 hours. He weighed in at almost 5 pounds. He died to maternal negligence. This board would not accept my grandson's death complaint. It has been 1 year and 8 months since we submitted his complaint, and we have absolutely no information as to where it is. What needs to change? You need to follow Business and Professions Code, Chapter 4, Article 5, Section 328, which requires this board to investigate all death and serious bodily injury complaints under the highest priority level. Give families the right to communicate with the board. Before you dismiss a quality of care death or serious bodily injury complaint, you must interview the complainant or surviving family member. In doing so, you will get the additional information you need to potentially move the complaint forward. Provide us information on your physician profile. We need to know the background of our doctors. If an 805 report has been received, note that on the profile, stating 805 report, loss of hospital privileges. If there has been a criminal charge, note that on the profile, stating 805 report, filed against a physician, note that on the physician profile as well with the actual charges. We need this
15
information
seconds.
to make the best decisions for our families. This board is denying rights to babies. My grandson was not the only baby whose right to have his death investigated denied. You also violated the rights of a 7-year-old Bakersfield daughter claiming the statute of limitations had run on her complaint, denying her the right to have her complaint accepted and investigated up until became of age. Our babies have equal rights as any other person, whether they live for 18
This is
hours or are still alive today. Don't be the board that denies babies the right to an investigation. Thank you.
All right, this is the moderator. Our next individual is logged in as Xavier de Leon. And Xavier, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
Or Watchdog. I'd like to thank Dr. Jensen for bringing this issue to the board. Like I've said before, the enforcement process needs to change because it's not set up to provide rights for patients. My son is a prime example of this, having only lived 18 hours, but died due to the lack of care that him and his mother received. We have fought this board to accept my son's death, and it's been just under 2 years since we submitted his complaint and have done everything possible and yet still don't have a control or case number. And in my experience, this board is denying rights for babies to have their own complaint and investigations of their death and lifelong harm. I also believe that this board is violating the code 328. And my son isn't the only babies whose rights you have violated. Please move my son's complaint and many other families' complaints to investigation, and don't be a board that denies a baby's rights to an investigation. And lastly, we can't discuss enforcement without discussing the Deputy Attorney General and how they are calling for the closure of complaints without the complaint entering the enforcement process. We're calling on the issue of the DAG to be placed on the agenda for the next board meeting. Thank you.
All right, this is the moderator. We'll move on to our next individual, Maria Ibarra Navarrete. And Maria, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I'm Maria Ibarra Navarrete. I am from San Jose, a volunteer with Consumers Watchdog. My brother died tragically due to medical negligence. His doctor committed a medication error, which led to his death. The medical facility nor the doctor failed to report the never event to me, which means they didn't report it to you. They are required to report a never event. One of the problems with the enforcement process is the lack of communication with family members. I understand that the medical board is working on a complaint notification system. You need to implement one as well. We need more information from you. There are no email notifications when an accusation is filed against a doctor or when a discipline is taken against a license. I support the fathers and mothers on our team. You cannot deny the right to babies to have their deaths and lifelong harm investigated. I also support the movement to make this board follow the law and follow complaint prioritization guidelines, which requires you to forward all death complaints to investigation. Thank you.
All right, this is the moderator. Our next individual who has requested public comment, Michelle Montserrat Ramos. And Michelle, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. I have the honor of working with these amazing families, trying to help them navigate through a complicated and broken process. I hope we can work together to improve this process for families. You are not following Business and Professions Code, which requires you to forward death and serious bodily injury cases to investigation. I know through my work with my team that you are closing many death complaints before they ever reach investigation. We need better communication with staff. Before a complaint is dismissed, we need staff to interview the complainant or surviving family member. I am working with our team to ensure that they are filing complaints with the Department of Public Health and other entities that back up their complaints. When we try to submit other investigation documents, please accept them. I have personally debated with staff and exchanged documents with staff for 8 months until they reopened a case. The documentation supported the complaint. I have much more to share with you that I will send in a letter. Please reopen the case for Bakersfield's 7-year-old daughter. She deserves the right to her own investigation, and she deserves the right to the exception for minors that all other minors are guaranteed. We are here to work with you and make the enforcement process better for everyone. Thank you.
All right, this is the moderator, and it appears that was our last request for public comment. Would you like me to close the Q&A panel?
Yes, please. And thank you for those comments.